Ladies and gentlemen, welcome to the second day of our event. I hope you enjoyed the evening event as much as we did. And thank you very much to our sponsors for that evening. But it was a very successful event. And we are very refreshed now. And so let us go directly into our agenda. What are we expecting today? Two big challenging cases, especially relating to digitization and relocation of functions. And we're going to look at permanent establishment topics from a different vantage point. And if we're going to have an international panel discussion as well, maybe you can say something about that. Well, of course, we want to look at the legal position of the taxpayer. And if you were with us for a long time yesterday, and if you feel this morning that you're a little bit fuzzy in the head, I can assure you that our speakers will clear your brain. First of all, we are going to we're looking forward to a short introduction by a highly esteemed colleague from the Netherlands. He participated in the discussion yesterday within the circle of experts. I don't have to present Mr. van der Hoef, but because everybody knows him, but for those people who don't know, let me give you some data. Since 1984, he's been working with the IRS in Maastricht. He studied at the Business University of Nierode, and he's been an auditor since the year 2000. That is different than Germany, and he is a trainer at the OECD events, and he participated at many international tax audits together with our German colleagues. Ladies and gentlemen, Larry van den Hoef. Good morning, ladies and gentlemen. First of all, I would like to thank the organizers very much for providing the opportunity to me to speak here, and also for the invitation yesterday evening. Mr. Eisgruber cooked extremely well. In any case, I really enjoyed the food, and there was plenty of drink as well. So it was a very successful evening as far as I'm concerned. I am looking forward to welcoming and speaking to you today on the second day of our Tax Audit Forum. And I can tell you that this is going to be a very promising day. There are two real cases, and in between that we're going to have a higher-ranking panel discussion. The organization didn't spare any costs and efforts in order to invite interesting participants from Germany and from abroad, from all over the world. The participants came from all over the world. In any case, they're meant to come. I can still see a few empty chairs from Canada. We've got a High Court judge. We're going to have an ambassador at the UN Tax Committee from the EU Commission. We've got a director of the Direction Générale Taxud, and a colleague of mine, or a countryman of mine, is going to be here as well. He's the president of the European Association of Tax Advisors. And Austria is also represented with a professor who isn't only well known in his own country and defining international tax law, but also in Germany. He's achieved quite a lot. So this interesting round will discuss the question, any rights left? This question relates to the rights and obligations, I assume, of a taxpayer who is confronted with an international tax audit. In my practice of more than 20 international tax audits, most companies involved were actually quite happy that we carried out the international tax audit. They were willing and happy to provide any necessary information. There were no discussions as to whether they should provide the information, nor were there any reservations as to, well, I can't give you that information. In most cases, the threat of double taxation for this group was removed. And in addition, the group obtained certainty about its tax position, not for the period under review, but right up to the present. And in some cases, and I shouldn't say that too loudly, there was some certainty provided for the future. In Netherlands officially, and in Germany, as you know, this is not allowed. This can only be done via the BZST. But in any case, the group knew how to continue business in the future. And in some cases, the companies actually approached us and asked us, wouldn't you please carry out an international tax audit? So we always welcome that, and if it is possible, we from the Netherlands will participate in that. The throughput time of these tax audits is normally less than a year. And I presume that the people here in this hall know how long an average mutual agreement procedure takes. And they will realize that this is far shorter and quicker than your normal mutual agreement procedure. And these companies were very much involved in the entire process. They participated in the conversations. They provided proposals to solutions, and solution proposals were discussed actively with the companies, because it doesn't make sense if we as a tax authority come up with a great solution and propose that, and after that we can't implement that for the one or the other reason. Then we have to start from the very beginning again. So in the companies were involved in the process of finding a solution. And contrary to a mutual agreement procedure, where the solution comes out of a black box, because the companies are not at all involved, and where the solution sometimes cannot understand the solution. They ask themselves, how did the tax authorities come up with such a solution? I participated in some of these cases, and afterwards I understood the companies very well, actually. In my cases, there were some companies as well who weren't as willing to cooperate in this international tax audit. Why becomes clear quite quickly. They were very reticent in providing information, and they stonewalled wherever they could. Nonetheless, that wasn't much good to them in the end. The consequences of this international tax audit was that the winners in one country and who were made accountable and didn't listen due to the functions, the asset used, and the risks that were controlled there. They were relocated from a low-tax country to a high-tax country. And the cooperation between several countries meant that loopholes that were used were closed for these companies. Also, wasn't there any positive outcome for these companies? Well, even these companies weren't subject to double taxation. And these companies also were granted certainty that what remains in the low-tax countries will remain there. The question only is whether these groups, and just as the groups who cooperated, waited for us to carry out the tax audit. The panel discussion hopefully will throw light on both these situations. And now the real cases. The fourth case deals with the fiscal consequences of a classical relocation of functions, in inverted commas. There's going to be an example to pursue the question of a digital transformation of companies, whether that could lead to a relocation of function within a company, i.e. a relocation of functions due to digitalization. This is a big question mark. And then you will also get some insight into some technical details relating to 3D printing. That is always a fringe benefit, as I would call it, of tax audits. You can see interesting companies and you have a takeaway for the next tax audit. The team that will present the fifth real case will deal with the effects of a reorganization. An Italian subsidiary will become a permanent establishment of the parent company. I wonder whether the German and the Italian law are similar. I don't think so. And the German and the Italian transformation law provides for surprises, and I can't imagine that there won't be any problems here. But that is not all. In a second step, the convention law has to be focused on, and we're talking about the allocation of refinancing costs and participation and rights. The German and Italian colleague will be talking to you, and I know from my experience that these colleagues didn't only have to come fiscal hurdles to reach an agreement, but the question, the language and cultural differences have to be overcome as well, or dealt with, and that is something that is often forgotten. Up until 5 years ago, that's a very short period, the tax authorities almost only worked on a national level, and the last 20 international audits that I worked on took place in the last 5 years. And those who participated in mutual agreement procedures have experience with foreign colleagues. And these delegations only come together once or twice a year. So the large majority of tax auditors have no international experience at all. And the collaboration that is required in these types of international tax audits in order to arrive at a joint conclusion doesn't happen on its own, even if you find a common language. That doesn't mean that what I say really is what the other person understands it the way I meant it. So advisors and companies, please bear with us a little bit. We have to learn in order to be as effective abroad as we are at home. And for you, it's perhaps customary. For us, we're still pursuing a learning curve. Luckily, the countries know that this collaboration is not always without some friction. And there are people in these international tax audits whose task is not only to focus on the contents, they're experts in rules for the exchange of information between nations, and they make sure that there aren't any misunderstandings due to a foreign language or things that are understood differently in a different country. This task taken over by Michael Marx, Kirsten Rösel, and my colleague Mistakes, and the Swedish colleague as well. They are here, and these colleagues have experience with international tax audits more than I, and they know the tax organization in their own country as well as abroad. They know the customs of the tax audits in the countries participating in these audits, and they make sure that the process of collaboration is as smooth as possible. the first time I participated in an international audit, I got angry during the negotiations. I left the negotiating table after an offer which I thought was a compromise was turned down. And for me, what they presented was not a compromise proposal. And I thought, well, this is not going to be successful. I'm going to go home. Luckily, there were colleagues there who had experience with this process and who held me back. These were big colleagues, I have to tell you, because I was actually pretty irate at that moment. So, to summarize, not only focus on the contents, but also focus on the dealing with the other person. Events such as this one in Munich contribute to international tax auditors sorting out cases without having to have a mutual agreement procedure, which sometimes takes many years. But that will be enough in terms of introduction. I don't want to go against the schedule right at the very beginning. The only thing that you and I can wish ourselves is a very informative and instructive day, and I thank you very much for your attention. Thank you very much, Mr. van den Hoff, for this welcome address to today's event. As you just heard, we're now going to move on to the first real case. We're talking about the relocation of functions due to digitization. And you will also obtain a lot of technical details relating to 3D printing. We've got two speakers. First of all, I'd like to present Mr. Andreas Saliger. He's a colleague from the Bavarian Tax Office. He is a specialized tax auditor for foreign cases. He's given speeches on an international and a national level. He'd given workshops at the IOTA, the European Association of Tax Administration in Budapest and Bucharest and Berlin. And I think in Bavaria everybody knows him. Then I would like to welcome Ulrike Wolff-Seeger. She is a legal counsel at the Bavarian Tax Office in the Foreign Department. She studied law in Heidelberg, and after that she did a postgraduate degree at the University of Edinburgh and at the University in Osnabrück. And as a solicitor and tax advisor, she gathered experience in an international consultancy in Switzerland and in Germany. And she was also a clerk in the German Federal or Central Office for Tax Affairs. Andreas Saliger and Ulrike Wolff-Seeger are going to talk about 3D printing.
Ja, einen guten Morgen.
Yes, good morning from us too, and thank you for that friendly reception. Yeah, had been introduced, digitalization and relocation, question mark, the digital transformation of the company is going on. Industrial 4.0, industrial revolution, these are the catchwords that keep us going, and where you see contributions. What does that mean, digitalization? There's a lot of coverage on that. And I'm going to introduce one of the most distinct summary. These terms stand for modern data exchange, production and automation technologies like e-commerce or cloud computing. And also 3D printing is part of Industry 4.0. And 3D printing, these are three main criteria. The automatic machine-aided production of products from fluid or powderized material on the basis of digital production data. And the applications are various. And you can have classic products from materials like plastic or metal can be produced. but also products that you find difficult to imagine, like food or even human organs like skin, or at least there's experiments going on. What is more important, experts say, is not the production of new products, but also the change in value-added chains and business models. This could be, for example, related to 3D printing, the digital development and production of products, and the digital trade with the blueprints. Changes of business models and value added. What do the tax consultants think of? That is the function of relocation, and that is the point of our presentation. Can the change of business models and business and relocations on the basis of 3D printing, can this be the subject matter, for instance, of paragraph 1, sentences 9 or 10 of the external tax law? And I would like to show you a classic case of relocation of function, which is the centralization of the spare part warehouse. Then I will give you a short introduction into the technology of 3D printing. And then I will focus in my presentation on to the initial example of developing differently the centralization of the spare part warehouse. And by using 3D technology, can this also be deemed as a relocation of functions? Within our two cases, let's look at a classic relocation case in order to come back into those regulations. And in classic relocation, we want to look at an automotive supplier, the EAG, who works in 2 different countries. And before you think of it, which countries we've got neutralized, and you don't find out. You will never find these flags, by the way. Then EAG is the strategy carrier, and EAG has the PEEP GmbH, that is the subsidiary working in spare part production, and it works on own responsibility, and it has a license to the mother company, and then also delivers to a V GmbH, which is also a subsidiary of EAG, and was responsible for local distribution of these spare parts that she gets from the GmbH. And she does that on her own account, and she also gets an EBIT margin that she's able to proceed with its activities. The AG as a group has obliged itself to send the spare parts to the contractual workshops, and that also applies to 15 years after the termination of the serial production. And that's why, for this reason, V GmbH keeps an extensive spare parts warehouse in reserve in order to provide supplies in due time. Now the following is happening. In order to, due to relocation, it came out in the course of reorganization, the costs for the spare part warehouse are too high, and now they're centralizing the activities with the EAG mother company, parent company. So the warehouse at the V GmbH is closed. It's no longer delivered directly, not from V GmbH, but it's done through EAG. V GmbH continues to work in local distribution, and she gets a commission as some remuneration. But also the remuneration of the P GmbH is also changed, and agrees that this is only done on contract basis and against a remuneration that is appropriate with regard to the cost surplus method. And now let's look about the regulations say about relocation and what it's going to look like. So what is a relocation of function, and what are the purposes of these function relocations? If there is cross-border reorganization measures, if a function is transferred to an affiliated company within such scope, then there's more than only the tangible assets that will be relocated. And also the non-tangible assets and the goodwill and the business opportunities also include that, and also will also be transferred to EAG. And that's why the perspective has changed. You don't look any longer at the individual assets, but you will now take an external view by using an hypothetical arm's length comparison. From the external point of view, you will take care and you will look at the reductions and the added value provided for the company in order to say what has been transferred with that business opportunity. And mostly this is more than the total of the individual assets that are being transferred. So talking about function relocation, then you will talk about the assessment of a transfer package. And if you don't have a function relocation, you still have to think whether individual assets are being transferred, and then they will also be assessed individually. Function relocation is covered by, in the external law, and with paragraph 1, section 1, paragraph 1, sentence 1, and 8.9. And then there's an administrative principle function relocation that also tells us what is meant by that a function is a business opportunity or business activity which consists of a merger of the same activities within the group, and that is being settled by certain sections or department of a company. That is the function relocation regulation. But even that does not really have then also the BMF letter also tells us more details. And we found different points in the literature. First of all, what is a function? Individual functions are the result of allocation of tasks within a company. The respective tasks do not have to comprise all elements which are in the important for added value. We also have some examples, and we found out what is interesting for us. Production, warehousing, and distribution as functions are important for us. And there's an organic part that is a goal-oriented, a delimitable activity using certain assets, in particular intangibles here, and the benefits for the generation of contributions to operating results. And also within this organic part, you can obtain benefits that also will be appropriately to eliminate delimitable effects on profit. So if you take these reasons, then in section number 1, you have certain case groups where it says the conversion of the production company from an own producer to a contract manufacturer can be a function relocation. That means the last doubts now should be overcome, and also the conversion of an independent dealer to a commission agent is mentioned here. And if you look at this case, then P GmbH used to be within the own responsible for paying the license, and it was also responsible for the function, and then V GmbH had an owner was autonomously responsible for distribution and the service provider. And now VGmbH was using the profit markup, and then the VGmbH is becoming the commission agent and gets only a commission in order to take care of its activities, but it does not. It's no longer exposed to losses. So comparing that with our case and related to our production, then of course there are pros and cons. It's not that always that easy. So first of all, one point is the clear specification, as we said in marginal note, the conversion of an independent producer to a pure contract manufacturer, the discontinuation of the other financial benefits associated with the own responsibility and transferred to a low-risk activity for the future. And the reduction of personnel is merely an indication that has not been taken. Can be an indication, but this is not relevant here. So what are the arguments that could speak against such a function relocation? So to start with, from the financial authorities' perspective, of course, this is a functional relocation based on the BMF letter. But if you take a closer look, there is no changes in the number of employees and the related costs. So can we speak about demerger? And that's why this is a function, and relocation was made if the same employees are still there. Can we talk about that then? And spare part production is not a substantial value added. Is there any profit potential that has been relocated? It's no risky activity that is converted to routine profit, because the orders of spare parts is secured and it's plannable, and no essential tangible assets are being transferred, because the production process is known to the industry. It's not patented. And These would be arguments that would speak against a function relocation. Now let's see for distribution what speaks for a function relocation in distribution. That used to be a local entrepreneur that worked autonomously and procured autonomously. Now it gets a appropriate EBIT margin. That means, coming back to warehousing, that is completely relocated. That's why you can talk about a discontinuation of the function as relates to distribution. You can assume a discontinuation, then so the profit potential has been relocated, and to the limited risk distributor. After that assumed relocation, there will be much less profit than before. So the arguments that speak against a functional relocation is that we only work in spare part production, and spare parts mostly are linked to the product that was sold before. Well, there's a certain value added included, but the product that was made originally is not worth anything without the spare part, or the spare part is not worth without the product, so that is closely linked. Then there's a risky activity that is converted to routine profit that is only changed here, but this routine profit will come back as a routine. And you could also think that there are various opening clauses, which is functional relocation, but these opening clauses say that you only take the assessment of the individual assets and you don't have this external view. And the distribution as such is now function as only conceivable in connection with the distribution of the products, and you could also think of the idea that we do not have a functional relocation. We were trying to summarize the whole concept, all the arguments that we gathered and by production and distribution, and then we believe that in terms of production there's a functional relocation that exists because it is mentioned very clearly in the administrative principles, and that's why the assessment of the transfer package valuation has to be carried out. However, when it comes to distribution, there's also a functional relocation that exists, but basically due to the fact that there are some intangible assets which have not a big high value, the opening clause cannot help in order to assess the individual assets with the customer portfolio used by the EHE. That's why you don't have this individual valuation of the tangible and intangible assets. Now let's move into technology of 3D printing. I mentioned that at the beginning is the automatic mechanical generation of objects made of, well, since we are talking about taxes and we're not engineers, and let me just say that 3D printing allows you to print out objects from different materials. Then there are different procedures used, and what they have in common, so they add layer by layer, and then it can be hardened later on. So what's the benefit of using such a process versus traditional printing or production? Thinking of a more complex component in a traditional production, you would create a tool, and then you design the tool, and then the individual part is being made. And if the complex product consists of various components, then they would have to assemble, which is the first benefit of 3D printing. You do not have different steps in terms of assembling different parts, but in fact you can produce the product as three-dimensional dimension, and you can produce it, which also leads to some cost reduction. And also when you have aviation and aerospace, where you have a lot of materials, and that's why you do not have that danger of cracks and fraction cases. So where do you use 3D printing today? Currently, it is mostly used in the production on the design of products for prototypes. That's quite widely used, and which is due to the fact that the cost factor in the traditional material processes, the costs are reduced per, with economies of scales, whereas in 3D printing, the cost per produced part stay the same. That's why it's still used in prototyping and design. I brought you an example from Ford that was published in a magazine in 2015, where an employee said, well, the development of a prototype costs in traditional production more than $100,000 and takes 8 to 16 weeks, whereas 3D printing, the prototype production, the same prototype takes less than 1 week and costs only a few $1,000s. When they made a survey, global companies said the following: 38% expect that within the next 5 years, end products will be increasingly made by 3D printing. I've got a few more facts about 3D printing. Worldwide, 36% of companies have experience or expect this to do. In Germany, already 49% of the production powers, and then in worldwide 3D printing revenues are $10 billion out of this. I was surprised by that when preparing this representation. 10% is exclusively done in Germany. And the industry where it is mostly widespread is currently the automotive industry, where roughly 80% use 3D printing already or planning to do that within the forthcoming future. What does that mean for the business models of companies? We said 3D printing, actually, that is the most important element is having the blueprint, the producer that is able to produce it in 3D printing and transmitting that blueprint. Experts believe that company will be able to no longer be the classic producers, but moreover they become the developers of the so-called blueprint for 3D printing, and that's why they're marketing that. And the actual printing and 3D will be done by, will be outsourced to third parties. Another change can be seen on the cost side. It can be seen here that 3D printing, because it is no longer that the staff intensive, is independent from wage costs. That's why experts expect that production locations that were working in or that have been relocated to Eastern Europe or China will come back to high-cost country by using the 3D printing procedure, which is also being confirmed by a survey, according to which 43% of the companies will assume that and expect that. Warehousing costs, 3D printing requires much less warehousing capacity, first of all for the supply materials, but also because production can be carried out on demand, so no longer the finished product has to be stored, and that's why this would lead to cost reduction. Logistic costs, we're living in a just-in-time principle. That means products are being produced just in time and then delivered to the OEM, but due to being able to have short-term printing jobs, then people believe that there will be much less goods to have been transported on the road. That's why logistic industry will be less important. And you saving much more the resources, and you would have much less waste, and that is also relevant for environmental aspects, and that's a highly economic aspect as well. You don't no longer have these long design and planning phases and periods before. That's why it's going to be much easier to enter into a market with a new product, and that's why you would need less capital costs.
I just mentioned some things will lose in significance, for example, the logistics industry, but there will be new segments that will develop, for example, 3D printers who will offer this service to companies. We talked a lot about the products and the change of the business model. One doesn't quite know yet, or there are different possibilities as to how companies may use that. On the one hand, they may change the product due to the new manufacturing process or their business models. They can do both. A big consultancy in 2014 developed a model and divided the companies into 4 groups. The first model contains companies, and they look at the possibility of 3D printing, and they also look whether they could improve their own product with this new method, but basically stick to their old products and don't have any change in the value chain. And here you wouldn't have a possible relocation of functions. Where is that used, this model? Here, as already mentioned before, the company would usually the 3D functions for product development or the construction of prototypes. In the Model 2, the supply chain is changed a little bit, but the product hasn't changed that much. For example, the production may move closer to the place of use. I've got more flexibility. When I need a product, I don't have to have it in storage, and I can produce it when I need it. And I can compensate volatility in the demand, and I don't have to have a large warehouse. So it is conceivable, if we think of our case from earlier on, that the Model 2 could be used. Model 3, here the product itself has changed. Companies use the possibility of 3D printing to come up with new novel products, to develop them and produce them, but they integrate that into their existing value chain. What is the advantage of 3D printing here? Above all, it can adapt to customer wishes. It can be, I've got a better product functionality, and I can react to market demands more quickly. And in Model 4, I've got the greatest changes in the product itself and the supply chain. I can adjust the product to customer wishes. The customer changes the product. I've got the production only at the place of use, so I'm quite far away from the site of the original production, and I changed the value chain considerably, since some of the savings will be transferred to the customers. So the entire value chain and supply chain will change considerably if we apply Model 4. Let's just keep the models 1 to 4, and we'll come back to that later and move on to a different aspect. We want to look at an alternative case compared to our first case. This is an alternative case and not a further development of the original case. Since we already had a location, if we took everything away and got rid of it due to digitization, I don't think there is a lot to be done. So let's go to the original case. We've got the producer and the distribution company V, GmbH, and we want to save costs here again. And the spare parts warehouse will be dissolved because we don't need it anymore. We don't transfer it to the EAG, but get rid of it completely. I don't need the production anymore. I don't need sales and distribution anymore, the work shops anymore. We only need the CAD and the 3D printer that you're going to use to produce the spare parts, and you obtain the 3D printer and the raw materials from a third party. That is going to be starting case, and we can see whether we can apply the relocation of functions to this case. So let's concentrate on the production again, and let's think about what arguments would be in favor of a function relocation. I've got an identical product that used to be manufactured by me and in future won't be manufactured by me. And if I give this to a third party, I might have set up the or licensed it. So the production goes to a third party, but as a fully fledged manufacturer, I would have licensed it. I've got complete responsibility, and there is a reduction of staff because I have to dismiss the people who were in production up until now. So, what arguments would be against the relocation of functions? Let us look at the term. Relocation means that something goes away, but something has to arrive somewhere else. So what does it look like here? The production is stopped, discontinued in the producing company, but the DAG doesn't receive anything that corresponds to that. I think that is a very strong argument against a relocation of functions. Other than that, we've got a similar argument as in the first case. Here again, we don't have a lot of added value in the production of spare parts, and we know essential intangible assets are transferred. Let's take a look at the distribution. Well, these are two sub-functions. Again, warehousing is discontinued completely, but here too, one has to say that nothing arrives anywhere else. But an argument in favor of a relocation of functions. The warehousing is discontinued in the distribution company. Distribution itself is discontinued completely as well. Before, the sales company was autonomous, and this is discontinued here in this case as well. So there has been a complete reduction of staff. The arguments against it are that the manufacturing of spare parts can only be seen in connection with the product. The customer base is a real asset, and no essential intangible assets, i.e. production processes known to the industry. So distribution not a function here as only within the group. So we weren't quite sure as to the result. We had discussions with Mr. Geoff as well. So production, a function relocation should not exist, we think, since the function has been discontinued within the group and transferred to a third party. What about in the distribution segment? The warehouse is dissolved because it's become obsolete. The price advantage is taken over from E for the new for the new technology, and the function relocation is, if applicable, conceivable. The distribution is necessary. It's moved away from V and arrives at E. So one could say that as far as the relocation of the distribution, you do have a relocation of a function. So beyond this case, we would like to answer some fundamental questions. First of all, let's take a look at the value driver in this new business model after introduction of the 3D printing method. The know-how of the 3D printing method that ultimately will be sold to the third party. This is an intangible asset and value. And so we can see that digitization is the success factor of the new era, and that also applies for the transfer price area, i.e. intangible assets will continue to become more important. OECD in the BEPS action points 8 to 10 dealt with intangibles, and the report is called Aligning Outcomes with Value Creation. In the first part, it is defined what is an intangible asset, and in the second part, and that is going to be very important for the introduction of these types of business models. That is the question, who has the added value and the profit from these types of business models after introduction of digitization? The next question is, what are the effects on the value chain in terms of taxes? There's a big area where the production costs are reduced, and who benefits from that? There are various impacts on the final price because the customer, who might be the third party, as in our case, will benefit from these cost advantages, or wants to benefit, but there could be big changes in the value chain within the group as well. So you have to ask yourself, how do the flows change? Where are the cost advantages? Who are they allocated to? And how can I see it from a tax point of view? And if it's cross-border, how can I make sure that there's a proper exit taxation? Production has gone, and the manufacturing and the 3D printing was transferred to the customer. And the question is, what is the advantage which is included in the license for the third party? From a transfer price point of view, who has the advantage within the group? Or who should that benefit be allocated to? As I mentioned earlier on, when I relocate the production function, then I have a relocation of functions because we have a change in the value chain. And I'm creating something completely new that didn't exist beforehand. So I have to ask myself, if something completely new is created that didn't exist before, do I have a function relocation? Or maybe not just a new function somewhere else in the world, which doesn't leave someplace and go somewhere else, but basically leads to the discontinuation of an old function in the original company. Let's move away from the transfer prices. Let's take a look at the direct tax issues that can ensue from digitization and see whether we can use present tax law to answer these questions. First of all, a third party or within the group receives the CAD file, and we think this is an tangible asset, but it is quite possible that other legislations consider this more to be a service or maybe as the sale of a finished product. So how do we deal with that if there are differing international views of this? How do we deal with conflicts of qualification? And abroad, is that considered to be a license and not seen as a license in yet a different country? And can the withholding tax be applied? What are the implications of BEPS? What are the impacts for us? In the action point 1, they deal with the digital economy. The starting point of the court is the observation that the profits and proceeds from the digitized economy don't take place in the country where the value is added or where the product is marketed. One looks at the effects of digitization on the economy, and it is examined whether the present taxation principles are sufficient in order to meet the challenges of a digital economy. The results are as following. One found that digitization is not an economy in itself, but comprises the whole economy. There are very complex issues that arise from the digitization of the economy, which are not BEPS specific, but of fundamental significance. In this BEPS 1 report, there was no recommendation for the international introduction of completely new regulation or margin notes as connection of the corporation to digital characteristics or a digital permanent establishment. BEPS recommends certain aspects of taxation, for example, in the area of permanent establishments, and we'll come back to that in a minute. And then one notes that the other technological developments resulting from the digitization of the economy need to be observed, and if necessary, other action may be necessary and needs to be defined. Two other action points included in BEPS are action point 5. We have to think about, if I withdraw license fees, whether they are subject to proper taxation in the country where they flow to. And I can't imagine a 3D printing happening with a third party, but that it happens within the company, and that could create problems, and one might be able to deduct operating costs. And in the incoming country, the taxation is a lot cheaper. And action point 7 with the permanent establishment, if they are within the group, whether due to the 3D printer that is on site, I might be creating a permanent establishment because as a manufacturing company, I have an influence on this technical equipment. And then I would have opened a new field where possibly there is no staff or very little qualified staff might be necessary, and I would possibly get problems allocating a profit here. The final question remains: are regulations necessary in international tax or in order to take the challenges of digitization into account? The AO is going to be adjusted to digitization, and the open question is whether not only the AO has to be adapted due to the change in the world, but also whether the income tax regulation need to be modified in order to meet the challenges of digitization, in this case the 3D printer, and to make sure that these are underpinned, to make sure that the taxation substrate stays here. It is conceivable that whole production units are closed down and staff dismissed, and I think this, of course, will have a huge impact on tax issues as well. To close, I would like to summarize our presentation as follows. Digitization of companies and the economy has arrived. It is there forever. The concrete impacts cannot be assessed yet. So what does that mean for the taxation law? Parts which are resulting from these changes can already be included, but as said in the BEPS 1 report, one has to observe whether an adjustment of the tax law as we know it now will become necessary. So I was faster than the slide. Thank you very much for your very interesting presentation. The closing of a warehouse function is an interesting thought. And I think one can say that the commentary from the economy will look different. I'm sure they won't accept that thesis. I would like to welcome Thomas Sieber of the BMW AG. He's the global head of tax. And he's been with BMW since 1997. And he is a member of the board of the Förderverein of iTech. And Dr. Gregor Gehauf, he's also a member of the BMW AG. He's responsible for tax or transfer pricing. Ladies and gentlemen, the comment by our hosts.
Thank you very much. Good morning from my side. So good, now cars are being printed, but only replacement parts. Otherwise, we would be worried about our job. But the future can come along with that, of course. It's obvious that digitalization is not only a mega trend, but also the industry will have to deal with it, and also the automotive industry. And also we in our company working in a digitalization strategy because we want to secure our existence and secure the competitiveness. So in this strategy, all business models are being monitored. All business models and existing models, business have to be questioned and have to be rethought in order to be successful in global competition. What is interesting, it's not about relocation. That means it's not that we're relocated to something in another plant because synergies or costs could be saved. No. This technological change comes from a consumer behavior of the customers. That means the consumer behavior of customers and their claim towards services and products force the employees to develop digitalization strategies. And those who don't adapt themselves to this changed digitalization behavior or consumer behavior would vanish from the market. And it's no longer enough to digitalize products or processes, but in general, you have to think about offers and processes that have to be changed. And also you would have to redesign new business models. Disruption, that's a widely used term, and that basically expresses it, which refers to the complete change and modification of business models and digital innovation. So we're seeing this that the German traditional brands in the past have vanished due to digital transformation. And what is interesting, completely new businesses come into industries where these companies were not working in before, specifically in the automotive industry, but also in the media. You see Apple, Google, Uber, working in automotive industry, which were never active in this industry before. And these companies use a completely different thinking, and they are not shy in touching topics like relocation and of functions or thinking of other laws in Germany like the work time law and 8 hours a day. They don't care about that. And it's interesting for us to see that we also have to think about our own laws and the tax law as well. And I think this has not been sufficiently prepared with regard to digitalization. You mentioned that we have to think about modernization because ultimately Germany needs wants to be the fourth biggest economy in the world. Looking towards an increased change speed, companies have to reinvent themselves and adjust. Also with a view to 3D printing, as an example, you can nicely see that your value-added structure will have to be flexible. And specifically our tax law, the German tax law and international tax law, we still stick with classic value-added chains with production, trade, warehousing. And I think we have to depart from that. And you mentioned that at the beginning with the BEPS initiative of the OECD, particular traditional tax law structures are supposed to be digitalized. And in the activity plan 1, you mentioned that, I can say it again, this is where the results and the consequences clear. The digital economy is increasingly becoming the economy itself. I think that clearly shows the transformation and the evolution that is going on out there, and that OECD also has understood. Until the digitalization of our tax system or international tax law system will be finalized, our challenge is now that digitalized business models, as you just mentioned them before, that they will be translated and that we also have to derive any consequences for the tax law and link it with today's tax law systems. And it's quite important that we do this on a moderate basis and not trying to find any exit taxation. If function relocation does not offer that, it's so easy. If a function stops to exist, you cannot relocate anything. So with that case, you cannot give that much comment on this case because the function ceases to exist, is obsolete, and cannot be relocated. But of course, we can discuss that. You know, the underlying case that you outlined, the pros and cons were highlighted, and I'd say if a company that makes own production changes into a third-party production, well, you would have to compare when you look at the contract, what about a third-party production? Could you discontinue the license? And the entrepreneur not always has to claim that the business model will have to be staying the same, because that changes as well. And if the license is properly terminated, then he can also become the third-party producer, becoming a prolonged workbench without necessarily having to carry out a relocation of the function. But then, of course, you would have to look into the contract details. Also, when it comes to the demerging of say, a distribution company to become just a service company, well, you would have to look at the agreements, the legal versus economic consideration. Is the contract being terminated properly? Will there be any compensation claim? That depends on the provisions contained in the contract. But, you know, third parties also make a contract when we have a contractual relationship within the group. And if something is being terminated properly, not automatically, this is called a function relocation. Dr. Gerf, do you want to add anything about the underlying case? No, you know, with the contractual relationships, you can also say that the contracts, I mean, OECD, BMF have acknowledged that contracts need to be safeguarded and have to be complied with, and the U.S. judge and would probably be interested in what is written in the 10-15 pages of contract, because the OECD comment of 150 pages are not being accepted. If at all, he would accept OECD anyway. You need to be careful that whatever's written in the contracts is not being wiped away. If you look at what the BMF wrote about function relocation, in marginal note 60 says explicitly that a termination in due time within the notice of the period of notice is not a function relocation. Mr. Naumann agrees. Yes, that's so important. Of course, you have to bear the consequences from terminating the contract, but actually a termination within the period of notice is not a function relocation. So talking about the modified case digitalization, you can be faster and more flexible in order to respond to customer wishes, and spare parts can be produced locally in the workshops. And of course, it's always a case of disruption. It's not what I would call an extreme disruption, because the product stays the same, but the value-added chain is changing. The existing business model will be changed. And apart from production, also the warehouse and distribution is becoming obsolete. So that's why we're not talking about a reorganization as such. This is rather a disruptive business model. Production is being discontinued, depending from the agreement provisions, and the workshops. It's being transferred to the workshops, which is a third party. So the business opportunity is something new, and a new business opportunity is being created that lies with E. And the original entrepreneur that used to produce no longer has a claim that in case of a disruptive business model, the old model is being continued. And that is changed by this digital transformation. When it comes to warehousing and distribution functions, are becoming obsolete because of the new technology. Only a CID file is being licensed and provided. And these are the questions you mentioned. What do other countries think of a license? Is it also withholding tax topic? But this is now function relocation, because IP always had been vested with IP with E. That's why nothing was relocated, and that there will be no final taxation. It's not about lifting synergies. It's just a change of the business model within the value-added change because of the technological change. Well, you mentioned that And also, when you think of the new OECD thinking, whom do you allocate the economic rights and the intangible assets? Those facts don't provide that much insight, but if you take a look at the case, you come to the conclusion that the AIG would be entitled. And the business opportunity derived from this new business model of 3D printing, I find it difficult to allocate it to anyone else but the EIG. And EIG has developed it as a new business model. And accordingly, you have to admit that the GmbH that might have known about it, but the business opportunity was not created for it. So it cannot be allocated to P&V. Further to distribution, in the cases of function relocation, Mr. Naumann said, okay, I've got an old product, now I do something new, and I give the old one to someone else. That is my function relocation. We were disputing about that. That's how it's written here, but it's not true here. So because there's a completely different story. Products can be produced by the workshops themselves. The business model is obsolete, has become obsolete. And a function being assigned, transfer, that's the difficult argumentation, because we learned there's also, the perspective of the assuming company, the receiving company, that is EIG. What do they get? The production of, they don't get the production from P, they don't need it any longer. They don't need distribution either, because the workshop does that alone together with the third party. So even the customer portfolio, you might discuss that, but since this is a supplier, and like I know our OEMs, us OEMs, then customer portfolios is with the OEM because they have access. You might discuss that, but from the perspective of the receiving company, it's quite clear that nothing is being transferred. And we also learned that the alternatives available have to be checked. Because the simplest alternative for EAG is is to say, I keep on going like it is, but I still use the 3D printer and say, okay, you got a license here, you can print out your stuff yourself, and then P and V GmbH will have to see what they're doing, and they're bleeding out. And that's why it will be difficult to use the argumentation that a function is being relocated. If I may add, the financial authority not always can require that the cheapest alternative or the most favorable alternative would be used. So if you have different options available, like in-house or third-party production, because as the parties have realized it, then this should also be material or relevant for taxation, and there are also principles and rulings. And it's also important that the OECD says that when you have an arm's length comparison and a function relocation in the group, it requires that the reasons for the relocations are being understood, and the pros and cons have to be assessed. And in this case, something new was developed, and the existing model ceased to exist. And that's why we would not reach a function relocation. My favorite note in the BMF letter, that is marginal note 145, it says that the company freedom of decision should be accepted. So it's remarkable that the financial authority writes that. Otherwise, the Federal Supreme Court has to be obtained. And so mostly they say it's liquidation, and it's all right for the company to do that. Of course, you need to take the consequences as the company, but basically you have to accept the decision freedom of the company, and that is included. And the hurdles of requalifying that are quite high. So the OECD is a bit clearer on that. But just to say that fictitious business case, which would be a functional relocation, and just assuming that as such would be difficult. Even the BMF letter provides that only if there is a true function relocation is being covered by that, which I cannot see, definitely. Well, apart from the functional relocation, there's also many other questions that we also keep us busy at BMW, specifically when it comes to big data and where do customers go? Are they in the cloud? Who's using them? Who's got access to customer data? You could also list further cases here, and that are quite relevant out there. Digital distribution as well, and we're also developing this. And by opening digital distribution channels where customers are able to configure, well, order and pay digitally. And that also goes to new questions. It's not only functional relocations, but it's also about VAT, the place of service or performance. And there are these concierge apps that every one of you use in the car. The question is also, who is the recipient of the performance and the service, and if he is in a third-party country, you have to get registered. There's so many questions with regard to VAT relevance that are not yet clarified. And also you mentioned that also PEs like servers and representatives of PEs specifically working in digital business models, thinking of e-commerce, then a goods supply warehouse and digital as a PE in e-commerce. So many questions. I think the tax law is not really prepared. But the question is whether everything in tax law has to be adjusted in order to cover the entire digital transformation, so that everything should be tax that is, worldwide. Digital also means it's about IP, and IP somewhere in the world. And who's got the right of taxation? And today's tax law does not provide the final answer. Thank you very much. Thank you so much. I think the items are clearly defined. It takes another 20 minutes until all coffee cups are being printed out. So we have a bit more time to discuss. Let's hear Ms. Müller-Gattemann. Mike is coming. Thank you. Two more remarks. First of all, it's the non-text. Well, best wishes for the new technology. It could mean that the right lane of our motorways becomes freer, where the assets of the German companies are rolling. Further to the question of functional relocation with this new technology, what I think of is a classic process that reminds me of that. So I know from a large company, brewery group, and they also obtain the hops from Bavaria. And the supplier of hops basically operates a large hop warehouse with the brewery. Now, the brewing company takes from that warehouse, which only becomes relevant for tax purposes. Now, if you're using a technology, and instead of having such a warehouse which will be delivered, if you would use a 3D printer, that would be the same. It's just a consideration of what happens economically, and which also is important for our tax assessment. Would you share this opinion? I believe when the process is just starting, there are drone deliveries, and there are many aspects where we are going to find in the future that functions are being relocated, that staff gets lost, and the digitalization is making progress on a different program. There was about the digitalization and whether robots could replace some tax consultants, and the answer is no. They cannot replace that because they don't have empathy and they don't have any fun. So in financial authority, we could use of them financial authorities because there's not that much fun. But the process is running, but it's also a political discussion. And then the next question, Mr. Schmidt.
Ja, vielen Dank. Also
Thank you very much. I would be interested in a statement of the colleagues from the tax authority relating to the argument that something is being discontinued and that this is cannot be a relocation of functions. This wouldn't have occurred to me either. The classical example of a relocation of functions is the further production of the Beetle in Brazil or Mexico. That is what we thought about. And then Brazil or Mexico or the manufacturers there would pay something for the obsolete assembly lane. But who would pay something for the technology to manufacture complex parts somewhere else if it's much cheaper to do that via 3D printing? And so a very complicated segment of the economy would disappear. So how could that be a relocation of functions? What is the third-party price? Who pays something for these tools? The point is that these expensive tools and the expensive production will no longer be necessary. That is the main problem. So I have the suspicion that we in the administration, and yesterday when we talked about profit allocation to PEs, that we're sticking to the complex rules that we created, and say that we're just going to accept things as they are. I'm critical here of myself as well. I don't like to use common sense, but if something that we don't need in production just stops, then this is not a relocation of functions. And I think one shouldn't talk about a relocation of functions just because the group is working across borders. If all of this were in Germany, we probably wouldn't even think about that. We wouldn't think about whether there are hidden reserves somewhere and these turned into money. So what are they meant to consist of? So I think this is a point that was addressed quite correctly. I'm always very involved with exit taxation. If it's really about looking at manufacturing circumstances here, infrastructure, hidden reserves, and so on that are created here, and then they disappear abroad. I always say, be careful, my colleagues. Now we have to do something, but and we have to tax something, but there has to be something there to be taxed. Well, I didn't know that you know that I work for the ministry. But we have to do everything correctly, don't you? If you go back to the slides where we solved the alternative case for relocation of functions, and our result is that this isn't a relocation of functions, so we agree. We did put a question mark in the title of these slides, and I think it's certainly not easy. We looked at sales and distribution more, even though you might not have a relocation of functions there as well. And the client base is transferred. So we can't find clear answers here. It's very much focused on the actual situation on hand. Maybe we should stick to the warehouse example because, Mr. Schmidt, I think here the problem will become clearer. Let me come back to manufacturing because that is something that we talked about very intensely in preparation. I agree with you. We don't need to create PEs artificially and have artificial relocation of functions, but we have to look at what is happening there. And I think we have to understand digitization as a whole. It's not just something that is being stopped and something new starting. The first thought, maybe there isn't a relocation of functions because the EHA doesn't manufacture anything, but the customer does it. And I think this argument doesn't speak against the relocation of functions because you have an outsourcing against a third party, and that doesn't mean that somebody holds a function. So that alone is not an argument against a relocation of functions. But what left and what was received, or what arrived, and the constellations are so manifold and relating to the actual facts on the ground that it's very difficult to find a general answer to this. is this a relocation of functions or not? You have to look at what was the product beforehand, how was it conceived or produced originally. And in today's manufacturing sites, you still have people, or you don't still have people who just have a manual function or activity. All of that is very, very automated with a lot of technology. So we have to look at the individual case and to see whether the production procedure that existed before has that completely discontinued, or isn't there something that is included in the 3D production method, and isn't there something that is used from the old method? Of course, this is also due to the fact that all of these terms are difficult to grasp. What is a function? What does that mean? In the change or transformation of the value chain, what can be relocated and what can't. So we are discussing the cases that where we said 6 years ago. Where legal terms are created by the financial authorities and they're put on paper, and that's something we have to deal with. And in a situation such as this in particular, I think Mr. Schmidt just said it quite correctly. We really have to look at digital business models, which will multiply in the years to come. These have to be translated into traditional business models because our tax legislation is still focused on the traditional value chain, and we have to think about the tax consequences. And if a function is discontinued, it no longer exists because something completely new arrives because of digital transformation, I can't relocate anything. We kept our case neutral as far as the countries are concerned. And what we thought about as well, maybe when you're thinking about a relocation of functions, you think about relocating a German manufacturing site abroad, but this is not the typical function relocation case. We have German principles with foreign contract manufacturers abroad, and if they become digitized abroad, we have in- and outbound cases which we treat equally, and we came to the result that there was a change in the value chain due to digitization would not be a relocation of functions. And if know-how IP were taken back into Germany, then the IP principle after the development of digitization, we would have the same result. If you have an inbound relocation, you would have to think about whether the criteria of a function relocation had been fulfilled. So an inbound relocation is something that always has to be borne in mind as well. Let me just add something. When it was introduced, I am a great fan of function relocation because you could have hidden reserves in the company which should be subject to exact taxation and which aren't patents, which aren't as tangible. And obviously, that is why the tax law came up with the term transfer package. And we're talking about a transfer package here. And he said that it can't be excluded, that there is a function somewhere, transfer package. But let's accept that. But that isn't all. Then you have to define the external price. You have to look at the ranges from the point of view the person transferring and the party receiving. This is a difficult task. I just thought it through just now, and it wasn't my example. The 3D printer, that was your example that we're talking about now. And if you have 3D printing, an old technology is replaced. You don't manufacture the parts anymore via tools. You print them, and the production of the tools will be reduced as well, and more will be printed. So where is the transfer package, and how do I value it? So that is a question that I have to ask myself. You came up with this example, not myself. I only have questions relating to that. I have a problem that everything is called a relocation of function. This is a very clearly defined term by law, and we have to see whether it is a relocation or not. What we normally defined as function relocation is linked to a transfer package, and this is to facilitate evaluation, but that means you can still check whether you have individual intangible assets or not. And then if you're dealing with intangible assets, you have a hypothetical arm's length principle. So to say that everything is a function relocation right from the beginning gives me the impression then if it's not a function relocation, then that's it. No, then the audit starts again. Then you have to check whether what has been made available, and if nothing has been made available or something has been discontinued, then that was it. And you have to look at that from a tax and business administration aspect. Sometimes you can't draw any tax consequences. My God, that might be just might be the situation. And that was somebody from the German ministry, and now German tax auditors. You're absolutely right, and I think both parties are correct, and I agree with them. Basically, it's a valuation issue, and that we have to deal with. And I think this came out in the presentation that we just heard, that of course you have to check whether something was transferred. Because at the moment the impression is created that it was a bad thesis to have a profit correction or adjustment. And I think the approach is quite right. One checked whether something was transferred or relocated, and one differentiated whether it was transferred to a third party or to an affiliated party. And in the field of valuation, one has to ask whether possibly a certain technology was discontinued or not. I think there is no doubt. And the tax audit would have my support if something is discontinued or is dropped, or if something isn't transferred, a discontinuation or a transfer. Those are the two big differences. If something is discontinued, you can't ask for something that is being transferred because nothing is being transferred. I think we all agree on that. So I think one should ask, and this is what is so exciting. If you look into the future, what would happen if, for example, the 3D printer were in a different country and only give them the right to retrieve the license? Because you just mentioned it, action item 7, that one might have a dilution of the term permanent establishment. And let me just throw a question to you. I'm thinking about an outbound situation as well, Mr. Sieber. So we transfer a residual function which could be the customer base. There is a certain group of customers and there are certain values attached to that. And what happens if this customer base, I don't want to use the term function so that Mr. Schmidt doesn't get worried, if this is transferred to a permanent establishment in a third country. I just want to provoke a little bit here. We learned from the 10th of November of this year that in section 12, paragraph 2 of the tax law, the paragraph 13 relating to outbound transactions has to be applied if there is no direct taxation. So the corporation taxes have been adjusted or adapted in the interest of the lobbyists. So, and now this asset is transferred to a PE and not to another corporation. So what happens to it? That's my first question, and I'm going to ask the representatives of the economy here what their idea is. And the second question, Mr. Gehoff, you said, well, an alternative scenario would have been that the the internal company sells the license right and the 3D printer to a third party straight away. And in that case, the M would have a fair market price, including the profit opportunities relating to the printing license and the 3D printer. And that would have been demanded, and that would have led to a profit on the M level, which would be subject to taxation. So what I want to say, if this value of the T goes to another affiliated company, and we pretend as if the parent company had sold it, then I think we would have received our fair share, and that is what we want to have, isn't it? We only want your best. The client base, Mr. Huschka, if there is no relocation of function, if something is discontinued that can't be transferred, then of course you have to deal with the topic of the client base, and that may exist for outside third parties, and one could have a right to remuneration or compensation for that. But the question is, isn't the client base with the E company anyway? What does the V to do with the customer base? So one can discuss whether a third party could have demanded a compensation for the customer base, or whether it isn't already with the company E, irrespective of the relocation of functions. Remuneration for the client base is certainly a contentious point that we could talk about. And you'd always talk about E and M, and oh, you meant the M is the mother company or the parent company. You agree this depends on what is laid down in the contract or the agreement. If I transfer the IP, and that is I have a right to that as EAG, and P can use it to a certain extent. I don't know why, if I come up with a new business model and I use 3D printers, and why would I demand license fee from the third party? So I don't know where the company P can get something. So, but maybe I didn't understand you correctly. Where does the company want to get license fee, from the P or from the E company? As soon as the license and the printer is sold from the E to the V company or V GmbH, we would always have an outside price for the profit potential included in the license, because if you sell it and don't sell it as a license model, then you want to use the future profits, and that have to be factored into the price. And then this and the cost for the 3D printer would be subject to tax on the E level, and that is the asset that we're talking about. So you're saying that the business model be changed in such a way that you take out the company P, but the company V would have the new business model. And of course that has to be priced, and then the license has to be allocated at based on the arm's length principle. You changed the whole facts to the benefit of the IRS just now. Well, ladies and gentlemen, the coffee cups have all been printed. We're at the end of our discussion round. Mr. Saliger would like to say something or summarize these statements, and then you can go to the coffee break. I'll be very brief. So you have to keep facts apart. Have I got a function relocation? Yes or no? That can be answered quite clearly. And if you transfer intangible assets, you have to define what you're transferring. Are you transferring the possibility of 3D printing, or is it the intangible asset behind the object that is being printed? These are two different issues, and to bring everything together and talk about questions relating to function relocation, that doesn't make sense at all. So you can see what the practitioners do. with our great regulations, that was the approach. And if you look at our first slide, we showed that if there is no function relocation, it's not nothing. Individual assets can be transferred, they can be evaluated individually, they can be evaluated hypothetically on an arm's length principle. So I think you can look at it more relaxed. If the tax audit comes to an audit and talks about function relocation, everybody shrinks. And last Monday, when we talked about for the first time, you asked how many function relocations actually existed that became subject to tax as a function relocation. And I think that is a question that we can take into the coffee break. No more to be said. Thank you very much to our speakers, our commentators, and to you. We will meet at 11:15 with our higher ranking discussion, Any Rights Left. Please come back punctually. Thank you.